I said in my video just a few days ago on Trump v. Barbara, the Birthright citizenship case, that I would have more to say. I would have more to add about the decision as I read it and thought about it and talked about it. On Wednesday, I was in Washington, D.C. at Georgetown University participating in Georgetown's Supreme Court Term in Review hosted by Professor Michelle Goodwin. She brings together a collection of legal scholars and legal journalists and then people like me to discuss the term, discuss the cases. And we had a very vigorous discussion about Trump v. Barbara, and it got me thinking much more about the decision and had me thinking much more about what I thought was the most important parts of the decision. And so here, in the time we have left in this video, it's not going to go too long, don't worry, I'm going to talk about what I think are the two most important parts of that decision. They are, perhaps surprisingly, not John Roberts' majority opinion, and they're not really Clarence Thomas's principled dissent, which ran like 90 pages and is, I think, a rambling mess filled with non sequiturs and a lot of shoddy scholarship. The two most important parts of the opinion, in my view, are Justice Ketanji Brown Jackson's concurrence to the majority opinion and Sam Alito's dissent. He joined Clarence Thomas's dissent, but he also wrote separately. Now, I'm going to urge you, I'll link it in the post here, I'm going to urge you to read Justice Jackson's concurrence. It is a remarkable piece of actual historical scholarship, quite rare on the Supreme Court, quite rare in courts in general. And I read it, and I think you should read it, as a decisive repudiation of the vision of the Reconstruction Amendments that Clarence Thomas puts forth in his dissent, in which it undergirded Clarence Thomas jurisprudence around the 14th Amendment. The key words in Justice Jackson's concurrence come in the introduction, where she describes the Reconstruction Amendments not as some special provision for the formerly enslaved, but, quote, an anti-caste, anti-subordination reset for the nation, not a mere spot treatment for the dark stain of slavery. So the first part of her concurrence is a response to Thomas's dissent. Thomas's dissent argues that the reason why the Birthright Citizenship Clause cannot apply to undocumented immigrants is that it was written specifically and exclusively for the formerly enslaved. It was, in his view, a narrowly tailored measure for Black Americans and Black Americans alone. And thus, undocumented immigrants, immigrants of any kinds, foreigners even, have no say to the Citizenship Clause. Congress can grant them citizenship, Thomas says, but the clause doesn't apply to them. Jackson has two responses to this. First, and I think this is quite funny, she notes that Thomas has been the key advocate for the so-called colorblind constitution, a constitution that does not recognize or see race whatsoever, does not see racial discrimination, does not see racial subordination, does not see racial remediation, does not see race. And so it's odd, Jackson notes, that in this case, Thomas is putting forth a constitution that is highly color conscious. Arguably, this even contradicts his opinion in Students for Fair Admissions, the affirmative action case from a few years ago, where Thomas even argues that the Freedmen's Bureau was somehow a colorblind remedy. It's funny. I mean, it's a sign of how bad faith and unserious Clarence Thomas is. I have a whole rant about this, about how the legal right treats Clarence Thomas as a prophet, but when you actually read his opinions, he seems kind of dim. And that his signature opinion of the past decade, Bruin v. New York, is an absolute mess that has made a nightmare of gun regulations, and that lower courts and the Supreme Court have spent every year since trying to fix it. But separate. That's a separate discussion. But I think it's funny that Jackson's just like, this is a very obvious contradiction in this guy's thinking. The bigger point she makes is to go into the history of the Reconstruction Amendments and the 14th Amendment. I've talked about this on this page. Jackson notes that the origins of the Birthright Citizenship Clause lie in the advocacy Black Americans made in the antebellum U.S. for their own rights. She goes through what are called the colored conventions, conventions of Black Americans held in free states like Pennsylvania and New York, where they discussed constitutional issues and they made petitions to legislatures, including the Congress. And in these conventions, Black Americans claimed the mantle of native-born. They asserted themselves as American citizens by birth. It's why they opposed colonization. It's why they opposed any efforts to remove them from the country. Because they argued, they asserted, were American citizens by birth. It's Black Americans and Black abolitionists and white abolitionists, as the decades go on, that take this notion of native-born citizenship and expand it. You see, prior to the Civil War, citizenship was often a state-by-state thing. Where you lived determined the scope of your citizenship or whether you ever had it. But the abolitionist movement, taking the lead of Black Americans, asserted that no, there is a single national citizenship that could not be abridged by any state, and that national citizenship is rooted in birth. In this, they were simply borrowing from long-standing common law rules, dating all the way back to medieval England, where birth on the king's soil puts you within the king's jurisdiction. There's some great recent scholarship showing how this applied to all sorts of people, travelers moving through the realm, merchants in the realm, all sorts of people, transient and non-transient. If you were born on the king's territory, you were subject to the king's jurisdiction. And Americans imported this into their understanding. You'll notice prior to the 14th Amendment that the Constitution makes no mention of citizenship, except when it's talking about eligibility for the presidency. And then it says one must be a natural-born citizen. That represents this common law tradition. And so Black Americans prior to the Civil War weren't asserting any kind of special right or special privilege. They were saying, give to us what we are owed. And this is what Jackson shows in her concurrence. But she also shows that Black Americans weren't simply speaking for themselves. They had a recognition that if anyone could be denied citizenship, everyone could be denied citizenship. And so they demanded not simply citizenship for themselves, but citizenship for everyone, a universal citizenship. And it is this vision of a universal citizenship which informs the writing of the 14th Amendment, informs the writing of the Birthright Clause, which in its original form, Jackson notes, was quite narrow. But then Lyman Trumbull, the Illinois senator who drafted the clause, who was the principal drafter, withdrew that version of it and put forth a new version that was much more universalistic than the previous one, that was written as to permanently settle the issue. And Jackson shows that in the debates over this clause, opponents raised issues that we're hearing today. Well, what about disfavored immigrants, in this case, Chinese immigrants? What about Gypsies, the Roma people, who were described in these debates much the same way as opponents of immigrants today describe Latin American, African, Caribbean immigrants, as lazy, as shiftless, as a burden, as transient. This was actively discussed during the drafting of the amendment. And the drafters said, yeah, so what? It applies to them too. Now, Jackson doesn't get into this, but if you follow the discussions post-ratification, you'll see that both the drafters of the amendment and Black Americans continue to speak of citizenship in these national and universal terms. John Bingham in the House, defending the 14th Amendment in 1869, asserts to an audience that the Declaration of Independence did not say all white men, it said all men, and that the amendment applies to all people. And Frederick Douglass gives a remarkable speech calling for what he calls a composite republic, in which people from all across the world can come to the United States and be Americans. And he specifically singles out the Chinese, whom, again, are the subject of much hatred and opprobrium. Jackson's concurrence is a full-throated repudiation of the view that Thomas embodies, which is that there is some sort of competition between Black Americans and immigrants, that they must be pitted against each other, that what immigrants receive, Black Americans lose, and vice versa. She says, no, this is a universalist amendment meant for a universalist and egalitarian conception of citizenship that's inclusive of everyone. That's what the record shows. That's what the law shows. That's what the Constitution says. Now, I said that there are two important parts of the decision, and the other part was Samuel Alito's dissent. There's no interesting line in Alito's dissent, no turn of phrase. He's not a great writer. The substance is what matters here. And in his dissent, Alito suggests that not only does birthright citizenship not apply to undocumented immigrants, that not only was President Trump's executive order not unlawful either under the Constitution or existing statutes, but, Alito says, President Trump even has the authority to retroactively strip citizenship from those people deemed outside of the birthright guarantee. Alito, like Thomas, says in his conclusion that extending citizenship to undocumented immigrants, to birth tourists, degrades American citizenship, and that he does not believe the 14th Amendment was written to degrade American citizenship. His assertion about the president's powers is frightening. It is radical. It would give the president, in essence, the ability to create a hereditary caste of people whose birth on American soil was not sufficient to grant them American citizenship. And here's what you need to understand. If the 14th Amendment does anything, if the Birthright Clause does anything, it is overturning Dred Scott. And Dred Scott stands for the idea that there is a hereditary caste of people who can never obtain citizenship in the United States, not because of birth, not for any reason. That is the central idea, the central holding of Dred Scott, that Black Americans, free and enslaved, could never be citizens. And so Alito and Thomas are saying that that's what the 14th Amendment permits. It's reversing the meaning of the amendment. It's a photo negative of the amendment. It's the opposite. It's not what the amendment says. And he would extend to the president vast power to strip citizenship from people, to render them stateless, to render them people without rights, without the right to have rights. It's one of the most radical and frightening things I think a Supreme Court justice has ever said, and that's why it's important. Jackson says in her conclusion that what the dissent is trying to bring into fruition is the legal regime of Dred Scott, and Alito makes that abundantly clear. And I think, looking at the reaction to the decision from Republicans, from people like J.D. Vance,
the people that I'm talking to, that you're talking to, are extremely disappointed in this. I do actually think there's a really big silver lining here, and that's the simple fact that a lot of legal experts expected this case to go the wrong direction by 7-2 or even 8-1. The fact that this case was a 5-4 decision effectively means that the concept of birthright citizenship, which is an absurdity to the 14th Amendment, that concept is hanging by a thread.
I think that if the right is going in any direction, it is towards Alito. Alito is very plugged in with the right. As I've argued, he's a Fox News grandpa. I think he's very much capturing sentiments on the right. And that's where they are going. That's where they are headed. It's trying to reestablish the legal regime of Dred Scott. And as I said in the previous video, this is why the most important conclusion to take from this case is that we must reform the Supreme Court. We must expand the court. We must ensure that losing a single justice doesn't result in the Constitution being fundamentally rewritten, doesn't result in the settlement of the Civil War being erased from the Constitution. We have to do this to ensure that the Reconstruction Constitution survives and isn't destroyed and replaced with a neo-Confederate Constitution, dedicated to the idea that some people are superior, that some people will be masters, and the rest of us will be slaves. Thank you, as always, for watching. Please check out this video and consider giving the page a subscribe. I'll see you next time.